Our next talk is from Robin Shellard, and it's "What do you mean it's 5 years minimum, but it's legal in Europe?" So without further ado, I'm going to hand over to Robin, who can kick us off. Thank you very much.
Thank you, Josh. I wonder if we can go on to the first slide, please. Not this one, that's the one. Now, this is not a firearm. It may look like a firearm, but it isn't. It's a Zoraki 914. It's made in Turkey, and no sports day would be complete without it. For starting your local three-legged race at the village fete, this is just the thing you need. It fires only blank rounds, and lots of them. As an optional extra, you can get a extendable magazine that fires up to 14 blank rounds, so you don't have to reload between the egg and spoon, the three-legged and the novelty races. But it can't fire a real bullet. The chamber's too small for any caliber, so it doesn't accept any round that's on the market. The barrel is likely to shatter, even if you do make your own ammunition, because it's made of inferior metal. Drilled into the top of the barrel, it is a small hole, and that lets the gases that are expelled when the blank goes off come out of the barrel. We call it top venting. The remainder of the gases expel the blank cartridge you just fired and load another blank cartridge into the chamber. It's every schoolmaster's dream, particularly in Turkey where they're manufactured. Now, you can't see it on the slide, but inside the metal blockage, there is a metal barrel is a blockage, and that screws into the barrel to prevent anyone inserting any object into it. Now, that blockage can be removed with an Allen key. The trouble is, though, if you remove the blockage, it doesn't work as a repeat blank firer, so you need the gases to automatically reload the next blank round. Now, the reason you need to have the blockage removed with the Allen key is to help sailors and those lost on the mountains, because into the barrel you can screw a little cup that holds a flare, and you can just see that cup at the end of the barrel, not screwed in, just above the detachable handle. Now, to fire the flare, you fire a blank round and the hot gases escape through the top vent, igniting the flare, and hey presto, off goes into the flare into the air, and before you know it, Prince William has arrived in his helicopter and he's whisked you away to safety, and everybody's happy. So, all thanks to the Zoraki 914, a must for Christmas this year, but only if you don't live in the United Kingdom. They say that in the United Kingdom, this is illegal. In the rest of Europe, it's legal, and you can purchase it in your local sports shop. You can go down to the same place you get your footballs and your trainers and pick up one of these as you leave. However, if you go on the internet, you will find plenty of places advertising these for sale, advertising them for sale in English, are more than willing to send them to you in England. Just don't. The irony is that, in fact, Zoraki do this model as an air pistol, both the .177 and the .22 air pistol model, which is perfectly legal in this country. So you could import that and it would look exactly the same, but it's an air pistol. Now, that's a real problem for your EU worker, who often produces this at school sports days in England, or while walking in the South Downs when it gets a bit misty, and fires off a flare, and the police come calling, and the police get a little jumpy when he produces this as his flare launcher. Why is it illegal? Is it an imitation firearm? Is it a real firearm? Is it a blank firer? Is it a flare launcher? Is it all of these? Gun law is complex and often uncertain, as we shall see particularly when we come to look at the Crown prosecution charging. If someone's found in possession of a working shotgun or machine gun or handgun during the commission of a crime, the sort you see in gangster films, then the law is pretty straightforward. It's obviously a firearm. Minimum sentence is 5 years. Do not pass go, do not collect £200 and go straight to prison. But often it's not as straightforward as that. We know that the firearm is often a torch or a mobile telephone that acts as a taser. Or the firearm wasn't designed as a working firearm, but only, as here, as a blank firer. Or some attempt has been made to make the firearm unusable, but through some cunning engineering work of your local police force armourer, a projectile has been expelled from the barrel with lethal velocity. Recently, I represented a man who liked country and western reenactment. Everybody has their pleasures, I suspect, and he also liked a little bit of homegrown cannabis as well. The police raided his house and they found 2 cannabis plants, a Stetson, a sheriff's badge, 3 imitation Colt 45s, and a pillbox which had a small amount of black powder in, and which if you ignite when you at your hoedown, you can go yee-haw as it goes bang. Everyone agreed he was a harmless eccentric. The force armourer was able to get, however, one of the Colts to fire by filing down a air pellet, putting some black powder into the barrel, igniting it, and sure enough, out came the pellet, went through a piece of plywood, and it was not only a firearm, but also a prohibited firearm to boot. So all of a sudden, my client was facing 5 years minimum custody, when all he was a rather sad man who liked going yee-haw and going bang with his Colt 45. So let's have a quick look at firearms and the legislation. The law is still governed by the 1968 Firearms Act, though there have been a plethora of amendments. So next slide, please. Section 1. This is a cut down version of Section 1 that I put on your slide. It states it's an offence to possess or purchase or acquire a firearm or ammunition without a certificate. The section doesn't apply to shotguns unless they've been sawn off with a barrel less than 24 inches, or importantly, most air weapons, but not dangerous air weapons, and that is defined within the Act, and we'll come on to that a little later on. It also doesn't apply to airsoft guns, and those fire plastic pellets and are used in a game very similar to paintballing, for those of you who are familiar with that. So, what is a firearm? Next slide, please. Section 57 is the interpretation section. That's a very important section when you come to look at what things mean within the Firearms Act. And what it says is a firearm is a lethally barreled weapon if it can fire a projectile with a muzzle velocity of more than 1 joule of energy. It's a prohibited weapon. Any component part of a firearm or prohibited weapon, so trigger, barrel on its own, that sort of thing. There's a list of them within the Act. And an accessory such as a silencer. So a silencer on its own can be a firearm. The other thing about firearm, this legislation, is that it is a offence of strict liability. These are absolute offences. So the fact that someone doesn't know that a torch is also a stun gun, or the imitation Colt 45 does in fact fire a projectile, in law is completely irrelevant. The law goes further than that. In a series of cases in the 1990s, the Court of Appeal held that merely holding a friend's bag, thinking the heavy object was a crowbar, when in fact it was a gun, is no defence. Nor is the fact that no reasonable person could have expected that the bag would have contained a firearm. If you got it, you're guilty. But just because you're in possession of a firearm doesn't mean you give up when it's claimed that it's a prohibited firearm. Even though that also is an offence of strict liability if you have a prohibited firearm in your possession. the prosecution still have to prove it falls within the legislation. Just because you are guilty of a strict liability offence doesn't mean that either you're guilty of possessing a prohibited weapon, which carries a minimum of 5 years imprisonment, or one of the many aggravated offences which also carry a minimum of 5 years imprisonment, such as possession with intent to endanger life. So what exactly is a prohibited weapon? They're called Section 5s for good reason, and there's a list of them, and they are in Section 5 of the Firearms Act. And can we have the next slide? Thank you. And again, this is a very much cut down version of Section 5. You can all go and look at it, and the long list that's in Section 5, both Section 5.1 and Section 5.1 big A. Now, what I have done here is that I've put onto this slide the two subsections that cause the most difficulty. So firstly, any firearm which either has a barrel less than 30 centimetres in length or less than 60 centimetres in length overall, other than air weapon, a muzzle loading gun like the old brown Besses you used to see in Victorian films, or a firearm designed, and this is important, as signalling apparatus. Next, any weapon or of whatever description designed or adapted for the discharge of any noxious liquid, gas or other thing, such as electricity. And then the closely related Section 5.1 big A, a person commits an offence if the authority has possession or purchase requires any firearm which is disguised as another object. And those last two subsections have caused an enormous amount of legislation, an enormous amount of case law, and an enormous amount of difficulty for many people. So, whether a person is charged under one or other subsection is incredibly important if you are defending. There's something of a subjective test carried out by the Crown Prosecution Service reviewing lawyer, but it makes a huge amount of difference. As we've just seen, the two subsections are not the same, but they have an overlap. It's a bit like Section 20 and Section 18 of Offences Against the Person Act. A police taser is obviously Section 5.1b, as it's not disguised. It's an either way offence. However, a torch, that's a torch, but also a taser and discharges electricity, there is a Section 5.1b, but as it's disguised, it jumps into the 5-year bracket as a Section 5.1 big A. Of course, in reality, it's no more dangerous than the police taser. They do exactly the same job. The only difference is one looks like a torch and one looks like a gun, the taser. So, how does the Crown Prosecution Service decide whether your object is a weapon that falls into a minimum of 5 years or one that doesn't? So let's have a look at their own guidelines. Can we go on to the next slide? And this is taken from the CPS guidance. Note on disguised weapons. Firearms which are disguised as other objects, such as stun guns disguised as torches or phones or other innocent objects, are prohibited weapons, and they fall into both of those subsections we've just looked at. The latter attracts a mandatory minimum sentence, the former does not. Where a stun gun is disguised, prosecutors should always charge Section 5.1b, unless any significant aggravating features identified in the case of Avis apply, and they're listed there. And then just below the case of Sheen and Sheen, it says this: unless a significant aggravating feature is present, the mandatory minimum sentence may be arbitrary and disproportionate. Where Section 5.1b is charged, the court may still pass a significant sentence. However, it can exercise its discretion as sentence where there is an absence of aggravating features which do not merit charging an offence attracting a mandatory minimum sentence. Prosecutors should note that where a stun gun is disguised as another weapon, Section 5.1b should be charged, absent any use or intent use of the stun gun, or the commission or alleged commission at the same time or recently of another relevant offence. Which in itself could be said to be somewhat arbitrary, because what they're doing is applying a almost subjective test as to where your client's taser, torch, foam falls. It always used to be the case that they would fall into the more serious category. Now, according to CPS guidance, they don't. They are always charged, even though they are disguised, as something far less than that. And that's why it's very important to have a chat with your nice Crown prosecution lawyer or prosecutor and say, look, my client, you may have charged him with the more serious offence, but really it doesn't fulfil the criteria in your own guidelines. Please can we have it down to the section 151B offence? Why? It's an either way offence. And if we turn to the next slide, this is the next bit of CPS guidance. Crown Court and Magistrates Court. Possession of weapons designed or adapted to discharge or noxious gas, contrary to section 51B, remains an either way offence and will usually be preferred where the weapon is a stun gun or CS gas. Case law suggests offences of straightforward possession with no aggravating features are kept in the Magistrates Court. So all of a sudden, the CPS policy, which has changed within the last year, has gone from a mandatory minimum of 5 years to something which will carry no more than 6 months in Magistrates Court. I'm going to come to minimum terms and the Court of Appeal approach in a moment. But before we do, we're going to return to the Zaraki 914 conundrum, because that was a firearm, it was a flare launcher, it was an imitation firearm, it was a blank firer, it was all of these, it was none of these. And that's quite often the problem that you're going to find when looking at some of the objects your clients are found with by the police. And quite often, as with the Colt 45 and the country and western singer, the problem is when the force armourer fiddles about with what your client thinks is an imitation firearm, and because they're the force armourer and they know their way around firearms, they manage to convert it into a firearm and it actually fires. So what happens then? Well, let's look at another piece of legislation, and it's the Firearms Act 1982, Section 1. And let's have a look at that in the next slide. Now, the Firearms Act 1982 concerns imitation firearms that can be readily converted into firearms. Readily converted means without any special skill and using the sort of tools you can find at B&Q. This is a non-strict liability offence, and there's a reverse burden on the defence. If they can show that they didn't know or could not reasonably have been expected to know, it could have been so constructed. Now, it's unclear whether that's a evidential burden or a balance of probability. So, if the prosecution have managed to get your imitation Colt 45 and done some clever engineering to get it to fire, then that isn't readily convertible. So you have a defence. But if all they've done is use an Allen key and a screwdriver, like on the Zaraki, then that's readily convertible. And you have another defence, and that defence we can see in Section 1, subsection 5. So let's get back to the Zaraki. What is it? And the answer is, it depends upon what expert you get. In this case, the force armour removed the blockage, put a blank round in the magazine, got a 2.2 air pellet, filed it, squashed it, bedded it in, put it in a vise, and fired it with enough velocity that it went through a small piece of plywood. But it therefore was a weapon, a firearm. Was it designed to do this? No. Will anyone know about this? No. only a force armour or an expert. Therefore, it became a firearm as defined by section 57. And so section 5.1 applied, as its overall length was less than the statutory minimum, and all of a sudden it's a 5-year minimum weapon. But just because the force armourer says it is something doesn't mean it is. Prosecution's still got to prove it. So often legislation will give you a number of defences. And here there were 2, but they were mutually exclusive. The first was that the Zerocki was an imitation firearm, not a real firearm. The Zerocki was converted into a firearm and its dimensions made it a prohibited weapon. That was done with no special skill, but that didn't stop it being initially an imitation firearm. If it was an initially imitation firearm, then 1982 section 5 defence applied if your client couldn't have reasonably expected that that was readily convertible. That's your first offence. The next offence is that it's a firearm that was designed as signalling apparatus, and that fell within the exception contained in section 5.1 ABA. That was on our slide 5. I'm not sure we can nip back to that and just have a look. Slide 5. Yep, there we are. So section 5.1 ABA, other than designed as signalling apparatus. And I've told you that the Zerocki screwed it into the barrel, fired the blank round, off went your flare, down came the helicopter. So the Zerocki was designed for flares. The Zerocki would not benefit from the exception unless it was a firearm and therefore lethally barreled. And there's some case law, case of Singh, 1989, Criminal Law Report 724, where a flare launcher was said to be capable of being a firearm. And it was a matter of mixed law and fact for the jury to decide whether indeed it was. So there you are. There's your 2 defences. And in the case of the Zerocki, unfortunately, no court has yet decided, because in this particular case, the judge decided they were pure matters of law for him. He rules matters of law against the defence, wouldn't allow the defences to be run in front of the jury, and we had to plead guilty. Now, we had leave to appeal, but of course the client got a non-custodial, he didn't want to go through with it. But the point that I make is that just because the prosecution say it's a firearm, just because the prosecution say it's a prohibited firearm, doesn't mean it is. If it's necessary, get a second opinion. There are plenty of experts out there to help you. So that's the problems with firearm law. Let's look at the problems of firearm sentencing. If you can't escape from a minimum sentence, try and keep your client calm. It's important to explain that 5 years may not always mean 5 years. And here we've got section 5.1a, minimum sentences, and in bold I put the exception. Unless the court is of the opinion there are exceptional circumstances relating to the offence or to the offender which justify its not doing so. And that is your get out clause. It's the only one available to you. The mandatory minimum sentence is 5 years imprisonment for an offender aged 21 or over, or 5 years detention in a young offenders institution for those aged 18, 19 and 20 at the date of conviction. 16 and 17-year-olds are subject to mandatory minimum sentences as well, but for them it's 3 years. It has to be committed to the Crown Court. Magistrates do not have jurisdiction over this sort of offence. Also remember, unlike drugs offences, there is no reduction for guilty plea. 5 years is 5 years, whether you plead guilty or you have a trial. That's your starting point. And also, unlike many other offences, there are no sentencing council guidelines that really help you, because what happens is you're referred back to the case of Avis, which you've already seen in the CPS guidelines. What type of firearm is it? What's it used for? What was the intention of the person who had it? What was that person's record? So what we're about to do is look at some of the cases that have been before the courts where, on occasion, that exception has come into play, and on occasion it's been successful. Not always. So let's look at first principles, and the leading case now for these sorts of sentences is a case called Nankaro. Can we have that slide up, please? It's next slide. Thank you very much indeed. And the legal principles were set out in this case, and it's well worth a read. The court has to impose a minimum term of 5 years imprisonment unless there were exceptional circumstances relating to the offence or the offender which justified not doing so. Circumstances would be exceptional if imposing 5 years imprisonment amounted to an arbitrary or disproportionate sentence. They had to be truly exceptional. It was necessary to look at all the circumstances of the case together, taking a holistic approach. The court also had to consider the kind of weapons that was involved, what use was made of it, the offender's intention in possessing it, and the offender's record. It was relevant that an offender was unfit to serve 5 year sentence, or such a sentence might have a significant adverse effect on that person's health. Each case was fact specific, and the application of the principles depended on the circumstances. And this is important when it comes to the fear of the judge being appealed. Unless a judge was wrong in identifying exceptional circumstances, or clearly wrong in not identifying exceptional circumstances where they existed, the appellate court would not readily interfere. Next slide, please. And there are two cases here which are again worth looking at because they go into the principles behind those sentencing remarks. In order to identify exceptional circumstances for the purpose of legislation, it is important to have regard to the policy and intention of Parliament, and the need to avoid a sentence which is arbitrary and disproportionate in respect of a particular individual. And those are the two key words that repeat again and again. If in any particular case, taking into account all the relevant circumstances, it appears that the case falls outside the range of cases which Parliament can be taken to have had in mind as the norm, an imposition of the statutory minimum may be said to be arbitrary and disproportionate. In such a case, the court may have little difficulty in concluding that the exceptional circumstances provisions apply. In the case of Jordan, Elaine and Redfern, the court explained that once a judge had properly identified exceptional circumstances, the sentence was at large. In that context, it was observed that he would take into account the guidelines of ABIS. The court also pointed out that cases in which real exceptional circumstances were present would be rare. And again, that is a constant theme throughout. So, in essence, your client being a nice person of good character who pleaded guilty and had no intention of using the weapon is not in itself an exceptional circumstances. And next slide, please. So it is, we turn to the case of Mr. Robert Burtell, and he had imported some blank firers, not once but twice, and was in process of converting them. Why? He just liked doing it. It was his hobby. He just got a thrill out of converting them. Nobody could prove any overriding criminality or any link to the criminal underworld. He just liked fiddling about with weapons. And he was given initially 30 months. The Court of Appeal were unimpressed, and they went on to this test, exceptionality test. The difficulty with such a test was that it did not provide any clear standard from which the exceptional case would differ. The judge's description in the instant case of it being neither ordinary nor wholly remarkable, not a helpful way of looking at the test to be applied. The instant firearms were potentially lethal weapons. The statutory purpose was to prevent such weapons coming into the hands of criminals who would deploy them in the course of committing most serious crimes. Conclusion: whether the imposition of the minimum sentence would lead to a sentence that was arbitrary or disproportionate had to be considered in the light of the clear statutory intent of the offences to which this section applied. So we go into deterrent sentences. and in some cases the sentence would be harsh, particularly when the offender had pleaded guilty. So again, escaping won't be easy. So what about useful mitigation? Well, I've prepared 2 slides that are, I hope, going to be quite helpful for you. And let's look at our next slide, please. So there you see at the top principles, the case of Nankaro, which you've looked at, Morton and Emergency's Advocate, which we've just looked at, and the next. There's a great song in Legally Blonde called the musical called Is He Gay or European? Well, here he's European, so therefore he doesn't get 5 years. Why? And I said that the 3 cases there. Case of Junkanaru, case of Rudups, and the case of Zekov. Mr. Rudups was a Latvian national. He pleaded guilty to unlawful possession of ammunition. The sentence was reduced to 6 months, which he had served, as when he'd entered the country, he had volunteered that he had this object, and it wasn't illegal in Latvia. So no minimum sentence. Mr. Zekov, the same. He pleaded guilty to possession of disguised stun gun. The offender was Bulgarian national. He had purchased the weapon illegally in Bulgaria and carried it into the UK without realising it was unlawful to do so. It wasn't a lethal weapon. It generated a low current and had never been used. He also escaped 5 years, though questionable whether now that wouldn't be charged as a section 5(1) big A. However, there are cases where that hasn't been the case. I've got 2 cases under the ignorance of the law defence. Case of Stoker and the Attorney General's reference number 82 of 2012. But let's start with that, because that's one of those cases I think that now the CPS would still charge as the more serious offence. And there, the defendant imported taser devices disguised as mobile telephones and knuckle dusters. It also bought stun gun batons and stun guns in the shape of knuckle dusters, and he was going to sell them for a profit. And initially, the court gave him a suspended sentence, and that was referenced. And the Court of Appeal stated that the statutory minimum 5-year term was intentionally draconian and was meant to act as a deterrent for the possession of these sorts of weapons. In the instant case, which concerned the importation of taser devices and stun guns, the recorder had been wrong to find that exceptional circumstances were justified. The fact that weapons were not lethal, that he was 61 years old, poor health, good character, had depression, all fell short of exceptional, and he got the minimum term. Compare that to Mr. Stoker, again, found in possession of stun gun phones, exceptional circumstances applied, he pleaded guilty, cooperated with the police, hadn't known they were illegal, so didn't get 5 years. Too unwell to go to prison, we've already touched on that in Nankaro, but there's a useful case if your client is slightly poorly or elderly or unwell. Next slide, please. On to some of my favourites now. I was going to hand it in honest, but I didn't get around to it. And here is the case called Boyle. Mr. Boyle had got a gun and ammunition after he'd been attacked in his home. A week later, he went to his local police station to hand it in, but because of cuts, the police station had been closed. So he rang the police and he told them that he had a handgun, he was hearing voices, feeling paranoid, he might shoot himself or somebody else. And lo and behold, within a few moments, the armed response team turned up and he handed over the firearm. And it was found to be a real gun with real bullets. And there, the judge found that the minimum 5-year term didn't apply because of those conditions. He fell into the exception. And the Court of Appeal said the proper approach was to determine the length of the sentence, the relevance to the relevant principles, and looking at Avis, and then consider whether it infringed prescribed minimum. I was going to throw it away. Again, that's one you could try. Didn't work for Mr. Harris, but worth a go. I didn't know it was what was in the bag. Boateng 2011, that did work. Going to commit suicide. These are also 2 ones worth considering because you have 2 very different outcomes. Poor Mr. Robinson got a gun to commit suicide. At the last moment, he bottled it, and he sat there looking at the gun for a week or so, not knowing what to do, until the police arrived and he was arrested. It wasn't exceptional, as he hadn't gone through with it, so and then didn't do anything with it, so he got 5 years. Compare that to Mr. Bates. Now, Mr. Bates had a history of suicide attempts, and he got a gun and decided that he wanted to be killed by the police in a shootout. So he went to a store, held it up, waited for the police arrived, and hoped the police would shoot him. They didn't. That was exceptional circumstances, and he didn't get 5 years. So there you are. If your client survives, it's all up to the court whether or not he's going to get 5 years. And lastly, this is going to be something that you may come across more frequently than going to commit suicide. And it's a woman who has been left to look after a firearm by a partner or associate. And it's a case of Ali, a very recent case, 2019, and it was unsuccessful. Mrs. Ali was 41. She was single. She had a number of dependent children. She said that she had been made to look after the gun, and there was a Newton hearing which she was unsuccessful in, and the judge found that she had the gun in return for financial reward. And what the Court of Appeal said was the defendant's personal circumstances and background, including a forced marriage at the age of 12, another arranged marriage, which was very unhappy, her experiences during those marriages, which were awful, and the severe restrictions on her education and her social and family life during her youth were not exceptional circumstances justifying the court to disapply the 5-year mandatory minimum sentence. Now, that may seem harsh, but there's a message that's been consistent from the Court of Appeal, in that too often criminals are said to allow weapons to be stored with people who aren't necessarily criminal, to mine them, particularly women. And so I suspect there's a public policy that offences or circumstances such as these will not escape the minimum term to put out a deterrence to others if they're tempted to look after weapons for criminals. That's been a review which I hope you find helpful, both into the law surrounding prohibited weapons, which you can see is complex, and also into the minimum 5-year sentences and how to avoid them. Remember, your first task is to get out of the minimum 5 years to begin with. Your second task, if you can't do that, is to use your skills as advocates in a way which we often don't do, to help your client get into the exceptional circumstances. Thank you very much.